What is up, everybody? Alright, I'm just trying to get everything finished being pulled up here. Sorry to have cut off the impeachment hearing like that, but and just when they were starting to talk about Burisma and stuff too, and of course we streamed all of the Democratic side, and now we gotta switch over to something else, and my internet's going crazy. So, I don't know how well this one's going to go anyway, but they are having a House Rules Committee hearing on HR 3621. That's what it is. I got the numbers mixed up. And HR 550. So, 3621 has to do with student loans, and 550 has to do with the Iran Act thing. All right. So I went through some of the documents for 550 in the previous stream during a break in the impeachment trials, but I will go through them again quickly. Okay, so 3621, and this is on house.gov. If you go to house.gov, you can click on right here where it has the little calendar thing for today. On the right hand side, and at 5 o'clock it has this hearing that we are going to be streaming, and if you click on that, then you will be able to get some of these documents. I also have some of the documents linked in the description box below, this one in particular and the text of 550. So if you want just the bill text, then they are both in the description box below. Okay, so this is to amend the Fair Credit Reporting Act to remove adverse information for certain defaulted or delinquent private education loan borrowers who demonstrate a history of loan repayment and for other purposes. Do I have my microphone on? Yes, I do. Okay. Okay, so they talk about the loan borrowers and how there wasn't enough transparency with the previous acts. They're going to remove adverse information for certain private education loan borrowers. They want to, as it said, pretty much allow the people that have demonstrated that they are repaying their loans to be cut some slack. The Bureau may allow a borrower demonstrating hardship to stop making consecutive monthly payments and be granted a grace period after which the 10-month period described in subsection A shall resume. Borrower demonstrating hardship defined. In this paragraph, the term, they're going to define it, is facing or has experienced unusual, extenuating life circumstances or events that result in severe financial or personal barriers. How about our government? How about hashtag the government? Is that such that the borrower or class of borrowers does not have the capacity to comply with the requirements of subsection. Okay, so my proof would just be like fiat currency. You guys and your fiat currency, okay? Procedures. The Bureau shall establish procedures to implement the credit rehabilitation described in this section, including the manner, content, and form, method for validating, manner, content, and form for notifying a private educational loan holder. So if you're interested in student loans, then this is definitely going to be a hearing that you're going to watch. Elimination of barriers to credit rehabilitation, a consumer report in which a private educational loan holder furnishes the standardized reporting codes described in subsection D to a consumer reporting agency, or in which a consumer reporting agency, blah, blah, blah. So, I hate reading through this stuff because I think they're actually going to say something, and no, they're just like defining this and saying the same thing 500 times. Payments by a borrower on a private education loan that are made during and after a period of rehabilitation under this section shall have no effect on the statute of limitations with respect to payments that were due on such private education loans before the beginning of the period of rehabilitation. So if you have student loans, then you might want to check this out. Again, it is linked in the description box below. This actual PDF, all you have to do is copy and paste it. It is downloaded from the actual government website. It's not like from, you know, a third-party host or anything like that. So no viruses for you. All right, and then the other bill, okay, so 550, the No War Against Iran Act. So they're saying they don't want Iran to have nuclear weapons. And Article 1 of the United States Constitution requires the president to obtain authorization from Congress before engaging in war with Iran. And remember, just recently they were like, hey, you weren't supposed to do those airstrikes. And Trump was like, but I was acting in accordance with the War Powers Act thing. And they were like, okay, well, we're just going to pass this thing now then. So, in that, the back and forth that was happening is that some people were saying, well, he was within his right because Congress had already authorized war back in 2002. So part of this is going to be repealing that announcement of war. Now Congress is finally going to say, after all of these years, okay, we're not in the war anymore, because, you know, Trump was like, but we're still in war. We've been doing this stuff. Okay, and again, I did go over this before, but it goes to say that nothing in the authorization for use of military force and use of military force against Iraq resolution or any other provision of law enacted before the date of the enactment of this act may be construed to provide authorization for the use of military force against Iran. So they're saying, no, any of the prior authorizations that we issued, no, you have to get completely new authorization now. And in general, except as provided in paragraph 2, no federal funds may be obligated or expended for any use of military force in or against Iran unless Congress has declared war or a new war, remember, because they're saying the one we already declared, no, we're repealing that, or enacted specific statutory authorization for such use of military force after the date of the enactment of this act, so after this passes. And exception, the prohibition under paragraph 1 shall not apply to use of military force that is consistent with section 2C of the War Powers Resolution, which representatives like Matt Gaetz said that Trump's actions were along those lines. It was in compliance with that. Nothing in this title may be construed to prevent the president from using necessary and appropriate force to defend the United States, allies, and partners if Congress enacts specific statutory authorization to relieve the executive branch of restrictions on the use of force, reporting or consultation requirements set forth in the War Powers Resolution, or to authorize the use of military force. So, little confusing at the end, which honestly, if you read the War Powers Resolution, I keep calling it an act, but if you read that, I agree with Matt Gaetz that Trump could fully say that, yeah, I was working within compliance of those guidelines. You know, I had information that was saying Soleimani was going to do X, Y, and Z, and according to the War Powers Resolution, I'm allowed to carry out these actions if I think someone is going to do X, Y, Z. So that's what I did. So let's see what they say about this. Thank you all for joining. I'm sorry I am rushed getting through all this. Again, both of those documents are linked in the description box below. Where do I get to? Here it is. Here it is. Okie dokie. Alright, it doesn't look like they are starting quite yet. Let me see if I can do this a little bit different. I hope you're all doing well. See if I can get a little bit better view of this. really gonna have that there? Oh, that's gonna be annoying. Okay. Alright. We're just gonna do this. Alright, so this is on YouTube. If our stream goes out, then they are streaming this one on YouTube under the, it just says House Rules, all one word, is, I guess, the channel that they're doing under this time. There's only 759 subscribers. Our government is weird. You guys, alright. Thank you guys so much for watching.
Whether it's Donald Trump or anyone else, should be able to use a nearly 2 decades old AUMF to assert military force without proper approval from Congress. Just a few months ago, this Congress, the 116th Congress, voted overwhelmingly, 242 to 180, in bipartisan support of this measure when it was offered as an amendment to the FY 2020 NDAA. The second measure is from Congressman Khanna to prohibit funding for military action against Iran that is not authorized by Congress. The situation with Iran remains volatile. If tensions should escalate again and President Trump wants to use force, he must come to Congress first, period. Article 1, Section 8 of the Constitution is clear. The President may be Commander-in-Chief, but only Congress has the power to declare war. It also makes perfectly clear that Congress holds the power of the purse. Once again, the members of the 116th Congress cast a strong bipartisan vote, 251 to 170, in support of this measure when it was offered as an amendment to last year's NDAA. Matters of war and peace are the most difficult things we consider. We all know and appreciate that. Sometimes they are votes members would rather not take, but the House has already spoken in clear, strong, bipartisan, in a bipartisan voice on each of these measures, and current events now demand that we do it again. Members of our military are willing to put their lives on the line for this country. We show our respect for their courage when we debate and vote on whether they will be sent to war and into harm's way, and how U.S. taxpayer dollars will be used for such military operations. It is the least that we can do. And if I may be so blunt, whatever political courage it takes for us to debate and vote on these issues, as the Constitution requires us to do, by the way, it pales beside the courage that our men and women in uniform and of our men and women in uniform and their families. We constantly call upon them to do their duty. The least we can do is our own. Lastly, we will consider H.R. 3621 to fix our broken credit rating system. When people apply for a car loan, an apartment, or even a job, their credit score can make or break them. But despite this rating's importance, our credit reporting system today is a disaster. It's outdated and often riddled with mistakes. So much so that the 3 major credit bureaus were the most complained about financial companies, according to the latest numbers from the Consumer Financial Protection Bureau. Enough is enough. It's time to modernize and improve this system so it finally works for all Americans. And before I turn to our ranking member, Mr. Cole, for any remarks that he wishes to make, I would like to acknowledge the presence of a distinguished guest who we all know and the audience here today. Charlie Johnson, the former parliamentarian of the House, is here, and we are happy to see him, and he is with his granddaughter, Holly, who is doing an internship in the Senate. I told her she would be far better served if she did an internship in the House, but anyway, maybe next time. But having said that, we're happy to see Charlie and his granddaughter. I'm now happy to turn this over to our distinguished ranking member.
Well, let me begin by associating myself with your remarks. Anybody would be better off in the House than the Senate. But
I go one up on you.
there are elements of bipartisan agreement here, Mr. Chairman. I want to thank you, Mr. Chairman. Today's hearing covers 2 different items. One is H.R. 3621, the Comprehensive Credit Act of 2020, a collection of 6 different bills arising out of the Financial Services Committee. And the second is the Senate amendment to H.R. 550, which the majority is using to bring up 2 items concerning war powers on an expedited schedule while employing procedural gimmicks to avoid allowing the minority customary procedural rights like a motion to recommit. I'll address H.R. 3621 first. Best I can say for this bill is that it is a bipartisan bill it is a partisan bill, on a topic that can and should have bipartisan solutions. Members of both parties can agree that reforms are needed when we consider how consumers access credit. In particular, we can all agree that regulations governing credit reporting can and should be reformed. We can agree that more needs to be done to address the student loan crisis, and we can agree that more needs to be done on health care costs and resulting medical debt that drives hundreds of thousands of Americans into bankruptcy each year. But instead of working together, the majority's chosen to yet again bring up a partisan package. None of the 6 bills that are part of this package had any Republican co-sponsors, not one. And not one of these bills secured any Republican votes in the Financial Services Committee. On a topic where there could and should be significant bipartisan agreement, I find that distressing. I look forward to hearing from our witnesses, and I hope they'll address why the majority's chosen to bring up a partisan package when a bipartisan one was possible. Our second measure is the Senate amendment to H.R. 550. However, the committee will be inserting the text of 2 different measures, the text of H.R. 5543, the No War Against Iran Act, and the text of H.R. 2456 to repeal the authorization of the use of military force against Iraq resolution of 2002. This follows on the House passage of a similar resolution that would restrict the president from using armed force against Iran that the House passed just 2 weeks ago. As the committee is aware, I've long been supportive of Congress exercising its authority with respect to war powers. I'm a firm believer that Congress has a role in committing America's military to battle. The War Powers Resolution of 1973 states clearly that the President cannot commit the United States to an armed conflict without the consent of the United States Congress. This is a debate we should have as a Congress. But once again, the majority continues to not take the need for actual debate seriously. Once again, the majority is pushing ahead on measures of the gravest importance without going through regular order. In contrast to passage of the original AUMF in 2002, neither of these measures has received a hearing or markup in the Foreign Affairs Committee, which has jurisdiction over these matters. In contrast to passage of the original AUMF, it seems likely no amendments will be made in order. And in contrast to passage of the original AUMF, even a motion to recommit, the most basic right offered to the minority, is being taken away. And all following consideration of a resolution 2 weeks ago regarding Iran, which also trampled upon the rights of the minority. Congress should have the opportunity to examine the justifications for the use of military force through a series of hearings and a markup to decide whether these 2 measures are appropriate. But instead, the majority is pushing them straight to the floor without following regular order. On the No War with Iran Act, I note that I actually supported this measure when it was offered as an amendment to the NDAA. I believed then that there was time for Congress to exercise its war powers and believed that Congress should go through an appropriate hearing process. But the majority has not done so. And since the NDAA passed the House in July of last year, the reality on the ground in the Middle East has changed significantly. Iran has directly attacked a U.S. base in Iraq earlier this month. And just yesterday, rockets struck the U.S. Embassy in Baghdad, although we do not yet know who launched those rockets. Iran continues to back militias and terror groups in Iraq, Lebanon, Syria, and Yemen. And it continues to threaten global trade through the Persian Gulf and the Strait of Hormuz. If this resolution were to become law at this time, it would completely hamstring the ability of the United States to respond to future acts of aggression by Iran. If Iran were to attack American civilians, regional allies like Jordan and Israel, or attack international shipping through the Straits of Hormuz, the U.S. military would be legally prevented from firing a single shot until after the successful completion of a bicameral legislative process to enact law authorizing the use of force. Mr. Chairman, we could and should continue to hold hearings and evaluate U.S. policy with respect to Iran and with respect to the entire Middle East. But without hearings and regular order, the No War with Iran Act is premature and potentially dangerous. I feel even more strongly about the second measure, which repeals the authorization for the use of military force against Iraq resolution of 2002. Much like the measure concerning Iran, no hearings and no markups on this measure have been held, and this resolution is being pushed straight to the floor without following regular order. Mr. Chairman, this is simply unacceptable. Members on both sides of the aisle, myself included, agree that an updated authorization for the use of military force that better describes our current threats is appropriate. But until we can reach agreement on what a new AUMF should look like, it is inappropriate to repeal the existing one. To be clear, I personally believe that we should rethink the 2002 AUMF, but we should not repeal it without a replacement. This measure fails to do that. Instead, it simply repeals the 2002 AUMF without providing any updated authorities. If this legislation were to pass, it would call into legal question many counterterrorism operations in Iraq and the broader Middle East, which is a reckless approach that will hamstring our military and prevent us from confronting ongoing deadly threats against our country. We need to follow regular order. We need to hold hearings on what a new AUMF should look like. And we need to reach a bipartisan, bicameral agreement on a new AUMF. I believe we can get there, Mr. Chairman, but simply moving a repeal measure straight to the floor without any hearings or any discussion of what a new authorization should constitute is not it. Finally, Mr. Chairman, I'm most disappointed in the procedural gimmicks the majority is using to bring up and push through these two war power measures. In bringing them up as amendments to a Senate-passed bill, the majority is using a procedural path that will blatantly deny the minority its traditional right under the rules to amend the measures through a motion to recommit before final passage. Under House rules, the minority is not allowed to offer a motion to recommit on any House measures that have been passed by the Senate. It is no coincidence that this procedure has been adopted on this measure. In fact, according to an article that appeared in Politico last Thursday, that appears to be precisely the majority's intent. Representative Khanna, who's the lead sponsor of the No War with Iran Act, is quoted as saying, quote, Majority Leader Hoyer has done an excellent job figuring out a procedure of how we can get a vote on the floor on these bills without an MTR that is non-germane and could divide the caucus. I seek unanimous consent to insert a copy of this article into the record.
Without objection.
Thank you, Mr. Chairman. As well as a letter from the Republican leader demanding the majority suspend consideration under these parameters.
Without objection.
Thank you, Mr. Chairman. Mr. Chairman, the motion to recommit has been part of House rules since the very beginning of the chamber and has been in its present form since 1909. It is the minority's last opportunity to seek to amend the bill on the floor before final passage. When Republicans were in the majority, we never sought to restrict the use of that right, recognizing its importance to the chamber. And yet, despite high-minded promises of openness and respect for minority rights that we heard from the new majority at the beginning of this Congress, we are instead seeing new procedures initiated and deployed by the majority that threaten the continued use of the motion to recommit. If the majority continues on this path, it will be a de facto change in House rules without a debate and a direct vote on the floor. And it will be done in a below the board way, simply because you're either too scared of what the minority will offer or too afraid to defend your own unpopular policies. Someday somebody's going to have to explain to me this fear that you guys have about MTRs. I've dealt with them my entire career. They're not hard to vote yes on or no on, but to be afraid to vote is just incomprehensible to me. I'm particularly distressed that the majority is making this move now on an issue of such importance to the nation. The decision to make war is the single most consequential decision Congress can make. I was under the impression that the majority wanted to have a sincere conversation about Congress's war powers. But given the procedural decisions that have been made and given the fact that the majority is now attempting to use a procedural gimmick to silence a minority, I'm now questioning that good faith. Let me be perfectly clear, Mr. Chairman. The motion to recommit is a right that the minority has held in its present form for over 100 years. Republicans never even considered taking away this right when we were in the majority. The Democratic majority has already taken away our right once and has threatened to take it again because they cannot or will not defend the progressive liberal agenda they seek to foist on the American people. For the present majority to do so now on a matter of such grave importance and using a procedural gimmick to avoid a vote by the entire House does a disservice both to the institution and the entire nation, and I stand with my leader in demanding that you change course immediately. With that, I yield back.
Well, thank you very much, and I appreciate your statement. And let me just say, I think it was said that the Foreign Affairs Committee didn't have any hearings on Iran. I think they had one a couple of weeks ago, number one. Number two, I want to say, before I respond, that the gentleman, I agree, the gentleman I know is very sincere, as other members on the Republican side in this committee, about trying to figure out how we get it right with regard to AUMFs and our War Powers Authority, as well as other authorities that executive branches, not just this executive, but Democrats and Republicans in the past who have served in the White House have tried to take away from us. But I just want to respond, if I can, to Leader McCarthy's letter, which I got a copy of as well. And I saw the letter earlier today that he sent Majority Leader Hoyer. I just want to say at the outset, in no way, shape, or form is this process that the minority leader is complaining about unprecedented. Over the last two Congresses, Republicans used a similar process at least 15 times. The Republican majority even hijacked Democratic bills to send unrelated measures to the Senate. In this instance, we're using a bill from Mr. Garamendi, a member of our caucus, to send to the Senate legislation related to the ongoing situation in Iran. Because a House amendment can be taken up without procedural debate under the Senate rules, this process will speed up consideration in the Senate and ensure that these important measures can move forward as quickly as possible. In his letter, Leader McCarthy is asking us to take matters of war and peace seriously. I think we are. But how does our record on this issue demonstrate otherwise? Since we have taken control of the House, we brought war-related measures to the floor time and time again, fulfilling our duties under the Constitution. I contrast that with what the Republicans did when they were in charge. And I don't necessarily blame members of this committee. I appreciate that some have even voted with us in Congress. I'd like to remind the minority leader that in 2017, House Republicans stripped from the DOD appropriations bill a bipartisan amendment from Representative Barbara Lee to sunset the 2001 AUMF. Representative Lee's amendment, as you recall, was adopted by the full House Appropriations Committee by voice vote. Republican leadership struck that language from the bill behind closed doors without a vote before the Rules Committee met on the legislation. In his letter, Leader McCarthy also decried efforts to, and I quote, erode trust, fairness, and comity in this institution, end quote. Can you think of any better example of something that does just that than what they did with Representative Lee's amendment? You know, I'll also remind the minority leader that during the Republican majority, the Rules Committee routinely blocked amendments on issues of war and peace, preventing full and thorough deliberation on the House floor. Many of those amendments were mine, so I recall them very, very well. Republican leadership blocked bipartisan amendments to require congressional action to increase troop levels in Afghanistan, to repeal the 2001 AUMF, and to repeal the 2002 AUMF, just to name a few. But I could go on and on and on. And I'll say one more thing. The Republican majority took the unprecedented step of turning off the privileged status of any and all war powers resolutions related to the ongoing conflict in Yemen in 2018. It wasn't until Democrats took control of the House that we were able to vote on a war powers resolution related to Yemen. And now we're facing a dangerous situation in Iran due to the actions of this president. But now more than ever, Congress must be involved in the decision to use military force against Iran or any other country. So we are using this process to ensure that the Senate can act as quickly as possible.
May I respond just quickly?
Gentlemen, can yeah, absolutely.
Thank you very much, Mr. Chairman. Very generous. Let's just talk about the Lee Amendment real quickly, because I was actually part of that in the Appropriations Committee. It's called legislating on an appropriations bill. It's actually against the rules of this House. And we did that to try and get the attention of our own leadership. We knew full well at the time there was no way that amendment was ever going to get through because, again, we were violating our own rules. Anybody could lodge a point of order against it, it would have lost. And I want to say, I reject
well, the gentleman could just say,
I certainly
with respect, I wish, you know, we'd have the debate over whether you should legislate on appropriations bills or not, but under Republicans and Democrats, there are examples of legislating on appropriations bills where we waive points of order to protect them from being knocked out of the bill. And in this case, again, you had a unanimous voice vote in the Appropriations Committee, and the way it was done was, again, as I pointed out, behind closed doors in a way that I think was not respectful of people's concerns on this, you know, on that very
Well,
issue.
as an appropriate, I can tell you, anytime we do legislate an appropriations bill, it has to be with bipartisan consent at the leadership level. We can't do it any other way. The second point I just wanted to make briefly, since you brought up the president, you know, it mystifies me. This president has actually been more reluctant to use force where Iran's concerned than any president in recent history. I just point to the recent history here. And we had a situation where the Iranians began shooting at ships in the Gulf. He didn't attack Iran. He appealed for international flotilla to protect, movement through the Persian Gulf and through the Straits of Hormuz. Then we had a situation where a drone was shot down, and our own military wanted a retaliatory strike against Iran. Who calls that off? The President of the United States. Because there was no loss of life on our part, he didn't want to run the risk of causing a loss of life on the Iranian part. Then we had an Iranian attack against Saudi Arabian oil refineries. Did he attack Iran? No. He sent additional defensive capability to Iran. Then we had attacks against American forces repeatedly in Iraq by Iranian-sponsored militias. Did he attack Iran? No, not until an American contractor was killed and 4 Americans were wounded, and the United States Embassy by Iranian missiles was assaulted in a direct attack on American territory. The history here, I think you're racing here to try and make look as if the president wants a war with Iran. He's actually been extraordinarily restrained. It wasn't until there was provocation and justification he chose to act. He made the act when no Americans were killed in the Iranian response. He did not go further. So I just, lay out there, I have a different view of this president's actions. He's been very careful about force in a very volatile region.
No, and I appreciate that. And by the way, I mean, whether you approve of what the president did or not is kind of beside the point. If President Obama were president and did the same thing, I would like to think we'd all be here talking about the need to make sure that we are involved in that decision. And by the way, when the previous administration took action in Libya, I think others as well, urged us to come back into session and to have a debate and to vote on that, because I didn't think that even President Obama, who I quite frankly thought had a more sensible foreign policy than President Trump, but I didn't think he had the authorization to do that and had the right to do that by cutting Congress out. So, I mean, what I'm saying here is that it doesn't matter what you think about Trump or whether you love him or don't like him. I mean, the bottom line here is we have, not just in this administration, but under Obama and under Bush, we have ceded our authority. And at some point, we're going to have to take it back, and maybe this is not going to be the vehicle we take it back, but that is certainly the way I look at this.
Well, again, Mr. Chairman, just one quick point in response. Sure. Remember, the president's justification was also under Article 2 of the Constitution. This was a direct strike back after an attack on American forces, which he has the ability to do. This was not a sustained operation in the way that Libya was, where for months on end, we bombed a country that had not attacked us, attacked our forces, was out of the terrorism business, had turned over. So to make that comparison to me obscures the difference between the Obama pretty reckless foreign policy and, frankly, a more restrained foreign policy by President Trump.
Well, okay. All right. We could go back and forth all day, but instead I'm going to go to our witnesses. I want to welcome our witnesses here today who will provide testimony. Oh, yeah, Mr. Hastings.
Just before you start, I do want to, because I'm older than everybody in here, remind everybody that when Japan attacked the United States in Pearl Harbor, without all of the modern technology, without all of the airplanes that could get people in places in a hurry, he was able to convene the Congress and declare war. Now, if they could do that in 1942, I don't quite understand why we can't do it in 2020.
Thank you very much. Now I'd like to welcome our witnesses to provide testimony on the No War Against Iran Act and legislation to repeal the authorization for the use of military force against Iraq resolution of 2002. Congressman Levin and Congressman Chabot, we're delighted that you are here. Anything you brought in writing without objection be entered into the record. I would now like to recognize the gentleman from Michigan, Mr. Levin.
Thank you very much, Chairman McGovern, Ranking Member Cole, members of the committee. I appreciate this opportunity to testify. I've come before the Rules Committee on behalf of Chairman Engel to support legislation to repeal the Authorization for Use of Military Force Against Iraq Resolution of 2002 and the No War Against Iran Act. Earlier this month, the President of the United States brought our nation to the brink of war. He ordered a strike to kill Iranian General Qasem Soleimani, the top general in that country, one of the top officials of that government, without consulting Congress as required by law. War with Iran is nothing like war with Libya. Nothing like it. He didn't consult with Congress as required by law, and he didn't provide evidence of an imminent threat. Secretary of Defense Esper said publicly that he wasn't aware of any intelligence supporting the president's claims that there were planned attacks against specific embassies. And Secretary of State Pompeo has ignored repeated calls from us to testify before the Foreign Affairs Committee on this situation. We're still waiting on him. According to the Washington Post, the president also reportedly carried out a separate unsuccessful strike against another Iranian official in Yemen at the same time as the strike against Soleimani, also without consulting Congress and without even claiming it was necessary to prevent an imminent threat. Iran retaliated with missile attacks on U.S. soldiers and personnel, and the United States is now sending thousands of additional troops to the region while stopping many of our counterterrorism efforts. After all this, we are no closer to achieving any of our objectives with Iran. This is the culmination of 3 years of foreign policy failures by this administration. The president's unnecessary and dangerous withdrawal from the nuclear deal with Iran, which of course wasn't a U.S.-Iran deal, it involved multiple other countries, which all agreed to it. And we had blocked Iran's path to a nuclear weapon successfully, according to all observers and reports, set us on a treacherous path of escalation. And where are we as a result? Iran's missile attacks this month injured and jeopardized the lives of Americans and Iraqis. And with Iran's subsequent announcement of their resumption of nuclear activities, Iran is that much closer to obtaining a nuclear weapon. This president has no plan to achieve the results we want with Iran, or to keep Americans safe, or to prevent another disastrous war in the Middle East that will cost billions or even trillions of American taxpayer dollars, and most importantly, American lives. That is why the measures before us are necessary and urgent. Let me start with Congresswoman Barbara Lee's legislation to repeal the Authorization for Use of Military Force Against Iraq Resolution of 2002. That law allows the president to use force to, quote, 1, defend the national security of the United States against the continuing threat posed by Iraq, and 2, enforce all relevant United Nations Security Council resolutions regarding Iraq. Let me underscore what that means. The law talks about a threat posed by Iraq, not in Iraq or emanating from Iraqi territory, but by Iraq. And yet, National Security Advisor Robert O'Brien has said the 2002 Iraq War Authorization gave the administration the authority to launch the strike that killed Iranian General Qasem Soleimani when he was in Iraq. It is true that the Bush and Obama administrations both stretched the 2002 AUMF so it could be used against multiple Iraqi actors. But there are two important points to keep in mind. First, just because a law has been stretched in the past doesn't mean it's legal to stretch it even further today. And second, no prior administration ever claimed the 2002 AUMF could authorize the president to attack Iran. Congress has not authorized war with Iran. To my colleagues who argue that Soleimani was a bad guy, I agree with you. I do not mourn his death. None of us do. But this does not change the fact that we are a nation of laws. The law here is clear, and the president did not follow it. And if we fail to respond, we send a message to every president to come, Democrat or Republican, that they are not bound by the law of this country and the Constitution of this country. We cannot let that happen. I also want to be clear that the 2002 AUMF is not needed for any counterterrorism operations or detentions. Today, the 2002 AUMF serves no function other than allowing the executive branch to claim Congress has already authorized a war with Iran. We must repeal this 18-year-old war authorization so that it can no longer be abused. But taking this current authority off the table is only part of the solution, because this administration has made clear that it is ready and willing to exploit every possible legal theory, no matter how outlandish, to avoid coming to Congress before going to war, as the Constitution requires. That is why we must pass Congressman Khanna's No War Against Iran Act, which would block funding for a war with Iran unless it is authorized by Congress, while still allowing the president to defend the United States. This measure does nothing more than enforce current law exactly as it is written in the War Powers Resolution. It does nothing to prevent the president from working with Congress right now if he believes he will need authorization. It just prevents him from ignoring Congress's authority to authorize war. This measure includes my bill, the bipartisan AUMF Clarification Act, which makes clear that neither the 2001 nor the 2002 war authorizations, nor any other provision of law authorizes the use of force against Iran. Without this clarification, we set a dangerous precedent, after which any future administration of any party might feel free to claim that a war authorization for one entity gives them okay to use force against another. I've made clear tonight that I believe the president's missteps have brought us to this dangerous juncture. I know, of course, that some disagree. To those colleagues, I respectfully ask that you consider the measures we're considering aren't about admonishing this president. They are about preventing a war today and avoiding dangerous precedents that will haunt us tomorrow. That is why I urge all my colleagues to support this legislation before us. Thank you again so much for allowing me this opportunity, and I yield back, Mr. Chairman.
Thank you very much, Mr. Chabot.
Thank you, Mr. Chairman. Thank you, Ranking Member Cole and the other members of the committee. I strongly oppose the two amendments to H.R. 550 that we're considering here today. Before I address the substance, Mr. Chairman, let me address the process. Since the Soleimani strike, we've had plenty of time to consider Mr. Khanna's legislation and any amendments to it under regular order. The Foreign Affairs Committee could have marked it up the week before recess, or this week for that matter. And as the chairman and the ranking member were discussing before, it was mentioned that, the Foreign Affairs Committee had a hearing. We had a private panel hearing on Iran, not on the War Powers Act and not on the AUMF repeal, and we had no markup of these measures. So I would note that for the record. Today, however, as Mr. Cole mentioned before, the majority has seen fit to bypass this process on the gravest subject that this body can consider, and that's war and peace, I think, as we all know. This irregular procedure will deny the minority the customary motion to recommit, as Mr. Cole mentioned, and that's just wrong. It also precludes more serious debate. Turning to the substance, let me first discuss the repeal of the 2002 authorization for use of military force, quote, to defend the national security of the United States against the continuing threat posed by Iraq, unquote. We all know that the primary purpose of the AUMF was to authorize force against Saddam Hussein's brutal regime. But what some of my colleagues are conveniently forgetting is that this law also mentioned al-Qaeda and other terrorist organizations threatening Americans as part of the continuing threat it was meant to address. In 2002, we couldn't have predicted, for example, the rise of ISIS 12 years later, yet ISIS did emerge, and President Obama used this AUMF, which my Democratic colleagues seek to repeal today, as authority for counter-ISIS operations, which are still ongoing under this current president, President Trump. The 2001 and 2002 authorizations for use of military force are outdated and imperfect. Thus, they should be updated to reflect the threats currently posed by ISIS, by other designated terrorist organizations, or by state sponsors of terrorism. We owe the American people a thorough debate because the threat of terrorism is not going to go away anytime soon. I think we all recognize that. But at present, the 2002 authorization is one authority we currently have, and until the majority sees fit to propose an updated alternative counterterrorism authorization, it is ill-advised to be taking tools out of our toolbox. Second, let me address the No War Against Iran Act. We should be very clear that neither the President nor Republicans in Congress are trying to start a war with Iran. This dangerous bill, however, assumes an ivory tower distinction that unless we are at war with Iran, we are at peace, and so directs our troops to stand down. Unfortunately, that is not the case. Yesterday, Iranian proxies hit our embassy with 3 rockets. In the past month, Iran directed a mob to attack our embassy in Iraq and launched a ballistic missile attack on U.S. forces. Over the past year, Iran downed one of our drones, attacked shipping in international waters, attacked a major Saudi oil facility, and had its proxies attack our bases in Iraq 11 times. And over the past several years, Iran has been working to achieve regional hegemony at the expense of our allies and our interests. Iran is operating somewhere between war and peace. And in the face of this, it's irresponsible for Congress to tie the President's hands beyond what is even contemplated by the War Powers Resolution as he seeks to respond appropriately. Instead, we should demonstrate that we have no tolerance for attacks on Americans and that such attacks will be met with overwhelming force. For these reasons, I oppose this dangerous bill and the repeal of the 2002 AUMF. Thank you. I yield back.
Well, thank you very much. I just want to clarify that for the record, unless I'm missing something here. Mr. Chabot, you talk about these 2 bills as if like we've never seen them before. My understanding, and if my recollection is accurate, is we voted for both of these in a bipartisan vote, attached them to the defense authorization bill that moved out of this House. We had a debate, and we voted on it here. And you talk about the 2000 AUMF and as if somehow we didn't want to repeal it when Obama was invoking it. We did. Many of us tried to do it back then when Obama was president. So this is not, in my opinion, a referendum on this president's foreign policy, whether you like it or not. I don't particularly think he's doing a very good job on foreign policy, but you may. That's fine. That's not what the issue is here. The issue is whether or not, if we cross a line and the hostilities are to increase, and whether or not he needs to come to Congress for an authorization. And for the life of me, I would also say the 2002 AUMF, that's 18 years ago. 18 years ago. And so, my friends, when they were in charge, had lots of time to try to revisit this issue, and we tried on a number of occasions to prompt Republicans when the majority to do it, to no avail. But I'm getting concerned that there are people here, not just Republicans, but some Democrats, who are content to leave things as they are, so that 100 years from now, they will be citing a 2002 AUMF to justify some additional type of action in Iraq or someplace else in the Middle East which is tantamount to a war. And so all this is, from my point of view, is about getting us to do our job. I mean, we go around, people, follow themselves to get to the House floor to say how much we support our troops and how much we honor our troops. And yet, when it comes to actually doing our job and making sure that we are engaged in a debate before they get deployed, before a war starts, we don't want to have any part of that. And I find that so disrespectful to our troops. I've talked to so many, when I visited Afghanistan and Iraq over the years, who have always expressed disappointment that we don't talk about what's happening. We're not doing our proper oversight. We're not debating the pros and cons of what our policy is. That's what this is. And so if the president decides to step it up with Iran, fine. There may be a majority in this House that will want to vote to give him the authorization to do so. We ought to have that vote. That's it. Not just say, okay, you do it because you can do whatever you want to do, and we're going to say nothing and make believe that we have no role. That's a violation of our constitutional responsibilities. Mr. Levin.
Yeah, Mr. Chairman, I'd like to just say something as a freshman, new to this place, and someone who, I idolize this place, and I still do. Maybe I'm naive. I demonstrated against the war in Iraq. I thought it was a huge mistake. It was a huge mistake. And fine, it happened. The idea, ISIS only exists because of that mistake. The idea that a war powers resolution passed a generation ago, Congress ought to be actively doing its job and have the guts to decide when we should go to war and when we shouldn't. And it's really the 2001 AUMF that speaks specifically about terrorism. That's there, and that's been this administration's main, thing that they've relied on. This 2002 resolution isn't appropriate. We've already debated it in the NDAA, but I think, to be honest, the only thing that would get this body to debate an AUMF is if we get rid of the old ones, and we force ourselves to step up to the plate and say whether the president is authorized to go to war with Iran.
Mr. Chabot?
Yeah, I would agree with some that my colleagues said.
Is your mic on?
Yeah.
Okay.
I would agree with a number of the points he's made. The one I would disagree vehemently with is to say that ISIS only exists because of that mistake. You're forgetting another mistake that followed that, if you consider that a mistake, and that's the fact that, and I've been in Iraq like many members here have been a number of times, and it was always anticipated that there would be a U.S. presence to stay there, whether it was 5,000 or 10,000 or whatever. But ultimately, the previous administration made a decision to pull virtually all the troops out, and that's when Iraq went to hell in a handbasket, when we saw the growth of ISIS, which literally almost took over Iraq and probably would have taken over Baghdad had the U.S. and our allies not stepped in. And I would argue that this president then, after that not being aggressively pursued against ISIS for a considerable period of time, this president really did take the handcuffs off our military and went in and defeated ISIS. So that's one point. The other point is, in response to your comments, Mr. Chairman, I think Mr. Cole said this too, we agree that the AUMF ought to be updated. But the only way that's going to happen is if we can do it together. That means Democrats and Republicans working together, but we ought not to throw it out before we have something to replace it.
Well,
that would be dangerous.
Yeah, well, and I'll just say again, I mean, my friends, with all due respect, were in charge for quite some time, and this AUMF's been around for a long time, and many of us, in a bipartisan way, tried to move in that direction. When you were in charge, nothing happened. We're now, and I think I agree with Mr. Levin. I think what will prompt us to act together, and hopefully in a bipartisan way, to come up with a new AUMF, and a more appropriate AUMF, is when we realize we can't rely on the same old to continue business as usual. And I think that's where we're going here. And again, we can have these, I'm not here to argue Trump's foreign policy or Obama's foreign policy. I've disagreed with Trump on a lot of things. I've disagreed with Obama on a lot of things. That's beside the point. The point is what our responsibility is in all of this, and whether or not we have a role, and whether or not we're living up to that role. I would argue we are not. We are failing badly. And it's not just on this, but on a whole bunch of other things that, quite frankly, we ought to be exerting our constitutional responsibilities on. So I think this will help get to that process that you want, Mr. Chabot, and I hope we can get there quickly. Mr. Hastings.
Mr. Chairman, I think that you have adequately put forth the proposition to support these measures, and therefore I appreciate our witnesses, and I don't have questions. But I would say this. Most of us, perhaps not Mr. Levin and some of the newer members, have been in the Situation Room at the White House or been at the SCIF in intelligence both here and in the Senate. In today's world, and perhaps it's regrettable that somebody just didn't insert this, the President of the United States could speak with the Gang of Eight in a heartbeat in a confidential setting without any problem. I continue to raise, and I will do so until you all begin to understand the changes that have taken place that need to be inserted in an authorization to use military force. And that is, I will repeat for you, Japan bombed the United States in 1942, and the president was able to convene Congress and declare war. Now, I don't understand. In those days, they didn't even have pay telephones, let alone the kinds of situations that we have today. And in this environment, not meant about President Trump, this should be done for this nation. And like Mr. McGovern, I was adamantly opposed to many of the positions in foreign policy that were taken by the Obama administration and expressed it. So this isn't about Donald Trump. This is about the United States of America doing our constitutional duty. Thank you, Mr. Chairman.
Thank you. Mr. Cole.
Thank you, Mr. Chairman. I would ask unanimous consent to submit two statements of administration policy, one related to H.R. 5543, the other to H.R. 2456. Both advise us that were either of these measures to become law, the President's advisors would recommend a veto.
Without objection.
Thank you very much. A couple questions, because again, this is a difficult subject, and frankly, there's a lot here on both sides that I can agree with. But a couple of things I want to make clear. First, I just have to say for the record, this fascination with defending Mr. Soleimani is beyond belief to me. Mr. Chabot, do you know how long Mr. Soleimani or Mr. Levin has been was a designated terrorist?
Many years. I don't
13 years. 13 years. Anybody have any doubt how many Americans he killed in that time? Probably not around this dais, I would suspect, and I'm sure neither of you. So let's put that on the record right away. And let's also add that, he was in Iraq illegally. There was a United Nations resolution saying he wasn't supposed to be traveling outside of Iran. And anybody that thinks he was there planning a vacation in Baghdad, I think not. He was in the company of Shia militia that literally the day before had been the commander of some of the units that had attacked the American embassy, or immediately before. So let's understand who we were dealing with. The president was perfectly within his rights to take out a designated terrorist traveling illegally. That's not an act of war. In terms of the Iranian agreement, we can argue all day long about it, but at the point, it was an agreement. It wasn't a treaty. Majority of this House opposed it. Majority of the United States Senate opposed it. President Obama put it into it. President Trump ran for president saying, I'm going to get you out of this agreement. He did that. We can debate the wisdom of that. There's nothing illegal or inappropriate about that. To take an issue to the American people and say, this is a bad deal and I'm going to get you out of it, I'm very glad that he did. And at that, he actually reflected the opinion of the majority of the House and the majority of the Senate, a bipartisan majority in each case. Now, in terms of the AUMF, this is an extraordinarily important topic. I actually agree with both of you. You have common agreement that this is something that needs to be addressed and needs to be looked at and needs to be reformed. I've worked with my friend, Mr. Governor, trying to do that in the past. Can you tell me why it wasn't worth, and I asked this to both of you, having a single hearing in the Foreign Affairs Committee about how we would proceed if we were going to get rid of something that's been there 19 years?
We certainly should. I think it's appropriate and necessary for us to hold those types of hearings because this is an extremely important topic. Again, as you said before, Mr. Ranking Member, we ought not to get rid of this until we have something to replace it with. And that's something that has to be done in a bipartisan manner, obviously, because the House is controlled by one party and the Senate by the other. If we're going to get anything done, we have to work on it together.
Mr. Cole, this came up in our Iran hearing. One of the witnesses spoke to it. They supported getting rid of this AUMF. We did discuss it. We debated it on the floor around the NDAA. There's no logic to saying it's dangerous to get rid of an AUMF that was about supporting going to war with, to get rid of Saddam Hussein. It's shocking to an American that this body will not deal with the current decade or century in terms of when we need to go to war and why. Your very points about how long Mr. Soleimani's been around, the president has the authorization to act alone if there's an imminent threat, if there's an urgent need to act. This guy, however horrible he is, there's no disagreement with that. And it's offensive if anyone says anybody's defending him. It's offensive to patriotic Americans. But the very fact that he's the highest general of another country, what would we do if, another country took out one of our highest generals when they were traveling?
It's equally offensive
just
to compare an American general to a designated terrorist of 13 years standing who we know had killed hundreds of people, who we knew was outside of his country illegally. That's offensive as well. They're not comparable
In
figures.
matters of war and peace, the question is, are we going to go to war with another country? And any scholar would agree that assassinating a general of another country, a top general, what we all agree, the mastermind of their worst things they were doing, is an act of war in any conventional sense of war theory.
He's not a conventional general, and interestingly enough, the Iranians did not take it as an act of war, at least have not pursued war against the United States.
I hope and I believe they don't want to go to war with us, and I hope we also will stop. I see no goal of U.S. foreign policy being advanced by going down.
Let me ask you this.
road.
If the aim is to develop a new bipartisan AUMF, and I certainly know in the chairman's case, it absolutely is to have something that's bipartisan. You think you're going to get there by going directly to the floor, or do you think you have a better chance of getting there by holding hearings, discussing, and devising something in the Foreign Affairs Committee, which is the committee of jurisdiction, where we could work together?
I totally agree with you, and that's why I support clearing this out of the way. This isn't about, what we're talking about isn't about getting a new bipartisan AUMF. It's a vote we already took in a bipartisan way to get rid of an old one that doesn't make any sense anymore. Let's clear the field and come together and debate what AUMF we need to now. And Mr. McCall and Mr. Engel, both, I trust them a lot to work together. They're really good at it.
I actually
I've
trust
been
them
impressed by that.
a lot, too. That's why I wish we'd given them the opportunity to do so in this case. I think it's a huge mistake, in terms of process and politically to go forward in this manner. Because this, as written, this isn't going through the United States Senate, probably never be taken up, certainly not going to be signed by the President of the United States. He's told us that today. So, again, I think you have an obligation when you want to do something to think it through and lay out, okay, this is how we're going to get it done in a bipartisan way. This isn't going to do it. I mean, we know that. so it just, the pace of this is to be charitable, self-defeating. Let me ask you this, if I may. The no War Against Iran Act amendment, should that amendment pass, what would be the implications of that? I'll ask you first, Mr. Shabbat.
Thank you, Mr. Cole. I'd like to see, as I mentioned, an updated AUMF to address the specific threats that we face today. I think most members would prefer a new authorization, as we said. There may not be a consensus yet. We ought not to, if we don't have that, then that's at least one tool in the president's toolbox, and ours to some degree, to allow us to respond to threats around the globe. My colleague mentioned before that the existing AUMF is so, how outrageous it is that we should still operate under it because its principal use was in Saddam Hussein's incident. But I would note in that it also talks about Al-Qaeda, it also talks about other terrorist organizations that are threatening Americans. And as you indicated, Americans have been threatened, most recently at our very embassy where they were under attack. So again, you don't throw something out that is still useful until you have the votes. That's the problem. We haven't had the votes in a bipartisan manner to actually pass something to replace it. So why in the world we would throw it out and then hope that because we threw it out, now we're going to be responsible? We ought to be able to be responsible and still have that backup.
So let me make 2 points, Mr. Cole. First, there are no counterterrorism operations that would stop if the 2002 Iraq AUMF is repealed. None. The administration claims the 2001 AUMF, which was actually about terrorism, authorizes all of them. The reference to Al-Qaeda was what we know now for the historical record to have been a false link, but that Saddam Hussein was working with Al-Qaeda. It was false, just like the weapons of mass destruction didn't exist. So it's unnecessary. The 2001 AUMF needs to be updated, but the 2002 AUMF does not need to be updated because it's not needed for any counterterrorism operations. So that's the first point. The second is, in terms of Mr. Khanna's bill, all this does is enforce the War Powers Resolution. If defensive action is allowed under the War Power Resolution, it's allowed under this measure. No problem. This should be a totally bipartisan thing. It's truly about just the prerogatives of this body. The important point is that if the president feels he needs more authority, he needs to work with Congress now. That's all this requires, because that's exactly what the War Power Resolution already requires. That's all it is.
Mr. Shabbat, do you think there's no consequences to repealing the 2002 AUMF?
The furthest thing from that, no, I don't think that's accurate at all. I think the consequences would be extreme and very dangerous for our country. And currently, it uses Congress's constitutional power, the purse, to proactively prohibit any use of force in or against Iran, with only a dangerously narrow exception for actual attack on the territory or armed forces of the United States. That exception does not include American civilians, diplomats, or shipping abroad, among other situations. The effect of this proactive prohibition is much more constraining than the War Powers Resolution, whose provisions cutting off the use of force do not kick in for 60 days. Iran and its proxies are actively attacking Americans in Iraq. We should not be limiting the president's ability to respond to these threats.
I just want to...
The 60 days is the exact opposite of the truth. The president can act for 60 days, and then he needs our authorization. Let's go to the wisdom of Mr. Hastings. If Iran is attacking American civilians and other things, we will work, and if there's a good reason to go to war with Iran, I don't know a single member of this body who isn't ready to work with the president right now on a War Powers Resolution for that.
Are coming from the same committee, and by stating opposite conclusions on this, sort of make my point that this needs to go back to the committee.
Right.
we're moving it forward before there's any kind of agreement as to how to proceed. I actually think, I wish the president hadn't invoked the 2002 AUMF because I think he had the authority under Article 2. I think there had been a series of Iranian attacks against our allies and ourselves and our soldiers in the field. He had every right to respond as he did, particularly against the target that he chose. And frankly, I see no evidence, given his actions leading up to that, which were extraordinarily restrained, as I pointed out earlier, and where he actually canceled attacks that would have been aimed at Iran and it would have caused Iranian deaths, suggests to me the last thing in the world he wants to do. He finally got provoked by the Iranians to the point that he felt like he needed to do something, and frankly, he's been pretty restrained after the Iranian response. So the whole supposition here that the president's racing pell-mell to war with Iran, I just don't think stands up to scrutiny at all. But the deeper question here of what we should replace with, that's what both these ignore. And where I think there is a good deal of common ground. But I think you got to work through the process to actually find what that is. Both parties have struggled with this because this is a different kind of conflict that we found ourselves in. With all due respect to my good friend, Mr. Hastings, it's not World War II. It's not with a nation state in many cases. It's with transnational terrorist organizations. That's what's made it difficult to grapple with. I remind my friends, they were in the majority for 4 years. They had a hard time struggling with this too. And I know they had concerns in that period of time. So neither of us have found the magic formula, if you will, that would allow us to be able to protect ourselves in real time and deal with these kinds of organizations. With the Iranian case, I just see this as very different. I don't want war with Iran. I don't think anybody does. I wish they would quit doing the activities they're engaged in. The largest state sponsor of terrorism, they've killed hundreds of Americans. I dare say more Americans have been killed by Iranians than Iranians have been killed by Americans. I want to go all the way back to the Marine bombing incident in Beirut in 1983. I mean, they've been at this for a very long time using a variety of ways. Our good friend, the late Mr. Soleimani, masterminded many of those ways. But I just think we're not going to get to where you want to go proceeding in the manner that we are. If you guys want to do it, go right ahead. You have the votes. That's fine. But it's not going anywhere in the Senate. Won't be signed by the president. And I think it will set us back rather than move us forward. I think the path that Mr. Chabot recommended of having the Foreign Affairs Committee sit down and debate it with two leaders that we both agree. I agree very much with you, Mr. Levin, that I have enormous respect for Chairman Engel, enormous respect for Ranking Member Recall. They have worked together repeatedly on issues and found it. I would feel better if this were in their court to do that, and your committee were working on it, than I do if it's going pell-mell to the floor with a Senate that's pretty poised to not take it up, and a president says, if you send it to me, I'm going to veto it. That's just not a way to get to where we need to go.
Mr. Cole, if I can make one final
I will, and then I'll yield back.
Thank you. I think your point,
unless Mr. Levin has a point, certainly let him make
Very
a point.
briefly.
I think your point about the allegation that this president has been rushing towards war, wants war, or that Republicans or Democrats in the facility took out half of their, taking out this terrorist general. So this president, anybody who alleges that he wants to go to war with Iran doesn't know what they're talking about.
Yeah.
Well, I really hope, from your mouth to God's ears, I really hope that's the case. And I really look forward to working with both of you on a bipartisan basis on this. Iran is not a non-state actor. It's a 4,000-year-old civilization. It's a country that's been around forever. What the topic at hand is war with Iran, not about terrorist organizations. That's all we're talking about. And we have had many hearings on war powers. We've had many hearings on Iran. We have a hearing tomorrow on Iran, but the Secretary of State is refusing to come. So we need to act. This body needs to act, and then we need to talk about a war powers resolution. Thank you.
Well, I would just add the body needs to act effectively. this isn't going to be effective. It's not going to achieve its objective. It's going to divide us. It's not going to unite us. And I regret that because this is something we need to do. I've tried to work with a variety of folks to get administrations to do that. I think there's all kinds of legitimate questions here to discuss, but I think it goes best through regular order. So with that, again, thank you for your generous time, Mr. Chairman.
Thank you. Ms. Torres.
Well, Mr. Chairman, I ask unanimous consent to correct the record. I misspoke when I said that Japan bombed Pearl Harbor in 1942. It was 1941. And just I have the stenographers know that. But with reference to my good friend, Mr. Cole, I recognize that Japan was and is a nation state, and that many of the things that we're dealing with are people that are not, they're terrorists. The point that I was making simply was that they had, for whatever reason and however they were able to do it in that period of time, they were able to call Congress into session. And with these matters, whether they're nation states or not, with all of the technology that we have, I just don't understand why we can't have adequate consultation with reference to anything having to do with bombing anybody.
Ms. Torres.
Thank you. I just want to thank you both for being here. I support both of these bills. I hope that everyone would support it moving forward. I would just ask, it's incredibly frustrating because we talk about war in a sense of dollars and cents, and Congress authorizing and Congress's responsibility to fund, whatever it is that we're going to get into. We forget about the loss of human life. We forget that we have to acknowledge the injuries, the fact that they are not just headaches, that they're traumatic brain injuries, and that it is our sons and daughters. And we forget that it is our responsibility as members of Congress, and we should not negate that that is our responsibility to deal with these issues. It would not be an easy vote for any one of us to send our sons and daughters to war. Absolutely not. But the choice that we have here is, do we leave it to a president who doesn't see the value of the Gang of Eight, who would rather consult with millionaires at his resort, that would rather talk through a Twitter account versus doing the responsible thing, and that is to provide Congress and the U.S. Senate with a proper classified briefing. Weapons of mass destruction, we still don't know. What were the threats that caused that we would murder a general? Not the nicest person in the world, absolutely. But we have to think beyond dollars and cents, and we have to think about the human value, and that's our kids. And with that, we need to repeal these, we need to pass these bills, and we need to move forward.
Thank you. Mr. Woodall.
Thank you, Mr. Chairman. It's not lost on me that it's a quarter after 6, and I'm the second one to speak on the Republican side of the aisle. But given that this is the only debate that's going to take place on these resolutions, I appreciate the extra time.
That's not true. We're going to debate on the rule and there'll be time to debate on the bills on the floor. I mean, okay, just so clarify
I
that.
take the gentleman's point. My experience in my decade here is that most of the thoughtful policymaking in this chamber happens in committee. I appreciate the role of the Rules Committee in making amendments in order, and I appreciate the 5 minutes on each side that each amendment gets debated on the House floor. But on matters of war and peace, I don't think 10 minutes is enough. Mr. Levin, you say you're a freshman here. I remember what that's like. That's the time that I started voting
to defund the AUMF of 2002. In fact, I remember it was been 2014, my second term here. Ms. Lee introduced that amendment on the appropriations bill. Dr. Burgess and I both supported it, as did the chairman, as did Mr. Hastings, and as did Mr. Perlmutter.
Jimmy, how much time do we have to debate on that?
5 minutes on each side.
Yeah,
Absolutely, as an appropriations bill.
Yeah, no.
Because we all know that when authorizing committees, and that's who we have sitting here today, when authorizing committees fail to do their job, the only opportunity we have is the appropriations committee. So yes, Mr. Levin, you're a freshman, but this is an issue that I've been voting on in the same way that my chairman's been voting. For the 10 years that I've been in Congress, for the 2 years that you've been in Congress, how many bills has the Foreign Affairs Committee reported on this topic?
Well, the House passed this to the NDA.
With respect, I'm asking about your committee. The chairman is absolutely right when he talks about failures in the Republican-led Congress, and I took those issues up with both the speakers that I had the pleasure of serving with. But my question is to you, because you're clearly knowledgeable on this topic, you clearly have passion on this topic, you clearly have a committee that wants to move forward on this topic. You said you looked forward to working in a bipartisan way with Mr. Shabbat and Mr. Cole on reaching a conclusion. And so my question is, how many bills has the committee reported on this topic? How have the authorizers done their work? Because the amendments I'm looking at look like bills that were introduced, bills that were referred, bills that had not one markup, and now they're showing up in the Rules Committee on the fast track to the House floor. It's not why you ran for Congress when you idolized this institution, to have something dropped in your lap and have the Committee of Jurisdiction do nothing.
Well, I was really proud when the House passed my AUMF Clarification Act. I thought that was really cool. And I thought it was a great day that that we would take the avenue available, which is funding our military, which is, kind of related.
I don't mean to be
To pass that.
I don't
So-
mean to be disrespectful,
Yeah.
Mr. Levin, but I agree with Ms. Torres. These are the life and death questions of our sons and daughters, which is why I have supported these measures day in and day out the entire time I have been in Congress. And my question is the committee going to report a bill? It seems incredibly cavalier to say, let's repeal something first and then we'll come back and do something later. I know that the answer to my question is no, the committee has not reported a bill. It takes no courage to vote to repeal funding. It takes no courage to vote to end an old AUMF. What takes courage is putting together the four corners of the AUMF to begin with. That's what takes courage.
Evidently, it's not true it takes no courage to vote to end an AUMF. I think that, as I said before, I think that if it takes getting rid of the old one, which is, this AUMF is of no use. It doesn't do anything. The administration is not relying on it. They're relying on the AUMF of 2001.
I heard you mention that to Mr.
Yeah.
Cole. I'm not a subject matter expert, but I have not seen that from the Pentagon. Who were those folks who came to the committee from the Pentagon to say that the 2002 AUMF was of no use in the global war on terror?
Well, we didn't. I'm not saying that they came and said that.
Was it the State Department that came and said that?
In their
or was it the Department of Justice on behalf of the FBI
in their
that came and
defense
said
of their
that?
actions, they've been relying on the AUMF of 2001, the Pentagon, which is what the part of the federal government that prosecutes war, not the State Department.
I say this to you as a Republican who has voted time and time again, as you would have voted had you been here for all of these years, to defund this AUMF. Is this the best that the committee can do? An amendment to a Senate gold medal bill?
I'm really ready to work with you on a new AUMF, but I'm fine with this to get rid of the one that doesn't work and that we've already voted on, and I don't see a problem with it.
I worry.
We've had lots of testimony from the Department of Defense and the state saying that all operations are covered under the 2001 AUMF. That's really not in debate. It's not a question. And this, you know, this AUMF is quote unquote against Iraq. It's not against Iran. You all can raise all the procedural issues you want all day and all night, and I'll stay here as long as you want to raise them. But the real way to honor Ms. Torres's point is to tell the president that if he wants authorization to go to war with Iran, he needs to come and talk to us about it, and then we have to have the courage to have the debate. 100% agree with you about that. My guess for the State of the Union is a woman whose brother served in Iraq. He came home wounded in his body and his soul. He was struggling about whether he wanted to live. She and her dad, also a veteran, went around to every gun shop in the little town of Charlotte, Michigan, and said, please don't sell him a gun if he comes, because there's only one reason he wants it. They all said, hey, we're allowed to sell it under the law. One of them sold him a gun and he killed himself. The consequences of war, the thousands of U.S. soldiers who died in Iraq and in Afghanistan, and the hundreds of thousands of civilians who died, the destruction of the infrastructure of Iraq, I take this all real seriously. Let's not fuss around on procedural points. Let's tell the president of any party, with all due respect, the Constitution says it's up to the Congress to declare war, and we need to do that if we want to go to war with Iran, with all due respect.
You're on your way in, and I'm on my way out. But I would share with you
You're leaving me.
that family...
I thought we were going to do, you know, create an authorization of use of military force together.
Get a year.
Okay, you're still on the hook.
That family deserves better than an amendment to a Merchant Marine gold medal bill. That family deserves, as do all the families in my district who have very similar stories, a full-throated, bipartisan bill that comes out of committee and settles this issue not once and for all. We have to come back and time again.
I agree with you.
It is unconscionable to me that you would have that kind of passion and that knowledge and that zeal for getting it right, and you tell me which Republicans you came to partner with so this doesn't turn into another partisan exercise. I voted with you every single time. You know who knocked on my door for this resolution? Nobody. You know who said, let's get together? Out the minority altogether. Let's skip the committee hearing process altogether, and let's jam it across the House floor the last week of January?
Like
The
I said,
new
both of
majority
these
in the House of
measures had
Representatives.
bipartisan support in the NDAA, and I'm not hung up on this, you know, these procedural points you all are wanting. I don't know what's, you know, maybe you're getting a lot of hay out of it, but
Lee.
I am for.
Mr. Levin, I control the time, and that is it. The procedural hay is coming from the majority that's jamming this thing through across the floor. The work I've been doing for 10 years to voting on this is not procedural hay. We've had chances to get things across the floor, and we've failed. You're frittering that opportunity away. You in the leadership. Again, if it matters of war and peace, with respect, they're not going to send a freshman to do that work. They'd send the committee chairman to do that work if we were actually getting around to doing the business this Congress should have been doing for the last 19 years. I just cannot believe, fair enough, if it's a health care issue, if it's a income support issue, go down the list, transportation issue of things we're going to do in a partisan way just to score those political points on late night TV. But this is, as Ms. Torres said, a life and death issue. Is the story you told of your family, one that has consequences that leave the battlefield and come back to our communities. And we could, again, as I say over and over and over again in this committee, we could have done this together. We could have done this in a way that could have overridden a presidential veto. But if there's anybody in this room who thinks that they've been doing the legwork to get this across the Senate floor and override a presidential veto, you know as well as I do that you're mistaken. I yield back, Mr. Chairman.
Thank you. And just for the record, in case anybody's confused, we are not debating a new AUMF here. We are not asking to bring new AUMFs to that's not what these two bills are. And I hope this committee plays a role in it as well, that we go through the difficult and painstaking task of trying to do doing the hearings, of making sure that that we hear from all sides, that we come up with a bipartisan approach. So I want to say to the gentleman, I do agree with him with his passion, and I can agree with him that that 10 minutes is not enough. So we will provide a full hour for each of these amendments. So that will be much more than in the past. But I will disagree with the assertion that we are somehow jamming this legislation through. This is a regular meeting. This is not an emergency meeting. These aren't emergency procedures. And my hope is that if we can do what we did in December and in a bipartisan way support this, then that will increase pressure, with all due respect, on the Foreign Affairs Committee and others to actually do what we should have done years ago. And again, I know it's difficult. I've had this conversation with Mr. Cole. Sometimes it's difficult, you know, if you're in the majority and your president is in the White House, to somehow begin to have this discussion, because it looks like you're trying to, you know, take away powers from that president. I mean, it goes on both sides of the aisle. But again, this ultimately is about Congress reclaiming its constitutional powers, and I hope that we can do that, and I hope we have, this leads the way to a thoughtful debate and a bipartisan AUMF that we all can agree on. Any other questions on our side of the aisle? No, I always love to hear from the gentleman. I just would say that I know we have Ms. Waters is waiting as well. So, but if you have, I'm not trying to dissuade you.
I'll talk to him offline. I'll pass.
Mr. Burgess.
Thank you, Mr. Chairman. There's not much I can say to add to the eloquent presentation that the gentleman from Georgia just put forward. But, Mr. Shabbat, let me just ask you, it does concern me that we would be withdrawing funding without providing for something to come in its place. Am I correct to be concerned about that?
I think we should be very concerned about essentially doing away with something that has worked reasonably well, something that all of us agree that we need to improve, but we shouldn't throw this out until we have something to replace it with. Especially when we're facing, you know, a terrorist operation in a country that basically talks about death to America routinely and has carried out death on Americans. You know, we talked about Soleimani before. We're talking about, we think in the area of 600 Americans, for example. Attacks on our embassies, you know, attacks on a whole range of other things. So I think it's very serious.
Now, the resolution or concurrent resolution that we passed a couple of weeks ago had as part of its language, the United States has national interests in preserving its partnership with Iraq and other countries in the region by combating terrorists, including the Islamic State of Iraq and Syria. Does the current AUMF passed in 2002, the so-called Iraq, and other countries in the region by combating terrorists, including the Islamic State of Iraq and Syria? Now, I went to the same classified briefing that I think everyone else did. I'm not going to speak to what I heard there, but it was not the 2001 AUMF that was cited by the Office of Legal Counsel.
So
I
the
can't
answer
say
is
what it
no.
was, but it was not the 2001 AUMF.
I just didn't quite hear what you said at the end. The answer is yes, in Iraq, and I would note, obviously, that the missile attack that took Soleimani out was in Iraq. He was there, as Mr. Cole indicated, for nefarious purposes. There's no question that they were plotting Now, exactly how many embassies, for example, and where they were and how imminent and all that, that's open to some questions. And obviously, some things are classified and others not. But there were some real dangerous things happening there, and I think it was very appropriate for this president to take him out. And I think the AUMF is, at least legally, certainly justifies it. And that's why we shouldn't be doing away with it. In response to what I think was a very responsible action on a president by a president who's been very restrained in his activities towards Iran.
All right, I thank you for that. I'll yield back.
Thank you. I think we're going to have to come back anyway, so I mean, if anyone has any additional questions or comments, or Mr. Perlmutter, we have to come back anyway. All right.
I'll do it offline.
All right. Anybody additional? Hearing none, then I thank you for being here, and you are now dismissed.
Thank you.
And that concludes the hearing portion on these two pieces of legislation. Do we have, can we try to get? Do you want to, should we start, Ms. Waters?
Well, yeah.
Yeah. All right, why don't we keep, is Ms. Waters here? Or is he get, or get these guys out?
That was the status of
Yeah, right.
In my view, we never.
Okay,
In my view, we never.
Mr. Levitt and Mr. Chapman, we love you here, but we got to get you to go. We have another panel. Yeah.
2011, when we
I would now like to call up our next panel to testify in H.R. 3621, the Comprehensive Credit Act. Chairwoman Waters and Ranking Member McHenry, we're delighted that you were here. Anything you brought in writing will, without objection, be entered into the record. Votes just started, so we want, as abbreviated as you'd like to be, we would appreciate it. But we may have to, we're going to probably have to come back if there are questions, so, okay.
Mr. Coldy.
Ms. Waters, turn your microphone on.
There it is. I want to thank you, Chairman McGovern, Ranking Member Cole, and members of the committee for having me here to testify on H.R. 3621, the Comprehensive Credit Reporting Enhancement, Disclosure, Innovation, and Transparency Act, sponsored by Representatives Ayanna Presley of Massachusetts. This package builds upon reforms that members of the Financial Services Committee have been developing for several Congresses. Mr. Chairman, credit reporting is unlike any other business. Consumers are not customers of credit reporting agencies. They are product. Credit reporting agencies package up consumers' data to sell to lenders, employers, and other businesses. Unfortunately, our system of consumer credit reporting is badly broken, and consumers have little recourse. Credit reports are routinely filled with unacceptable errors that are difficult for consumers to correct. A major Federal Trade Commission study found that 1 in 5 consumers have verified errors in their credit reports, and 1 in 20 consumers have errors so serious that they would be denied credit or need to pay more for it. This means about 42 million consumers have errors in their credit reports, and 10 million have errors that can be life-altering. Errors in credit reports are not the only problem with the system. For example, negative information stays on a person's credit report for periods much longer than its predictive value. Systemic racial disparities are also a problem in credit scoring. Medical debt continues to harm the credit standing of otherwise credit-worthy consumers. Just last week, we learned that FICO was making changes that would result in a big decline in credit scores for millions of Americans. All of these problems directly impact how much our constituents pay for a car loan, whether they can get a mortgage, and in some cases, whether they can get a job. Consumers are frustrated with the current system In 2018, the Consumer Financial Protection Bureau received 126,300 consumer complaints on credit reporting, which was the #1 complaint and which represented more than 1/3 of all complaints submitted. Congress needs to help Americans address these issues by passing H.R. 3621. The legislation includes H.R. 3642, the Improving Credit Reporting for All Consumers Act, sponsored by Representative Alma Adams, which would address burdens consumers experience when trying to remove errors from their consumer reports, including by providing a new right to appeal the results of initial reviews about the accuracy or completeness of disputed items on the report. The consumer reporting agencies would be required to train their personnel to better address consumer concerns throughout the dispute resolution process. Also included is H.R. 3622, the Restoring Unfairly Impaired Credit and Protecting Consumers Act, sponsored by Representative Rashida Tlaib. This part of the bill would limit how long adverse credit information stays on consumer reports, which currently can last up to 7 years, and reduce that to no more than 4 years. The bill would limit the time bankruptcies may stay on credit reports, which currently can remain up to 10 years. That we would change to 7 years. The bill would also protect consumer victims by removing adverse information related to predatory, discriminatory, or otherwise unlawful loans made by a financial institution. It would also prohibit reporting debt relating to medically necessary procedures and delay reporting adverse information related to other medical debt by 1 year. The package includes H.R. 3614, the Restricting Use of Credit Checks for Employment Decisions Act, sponsored by Representative Al Lawson. This part of the bill would prohibit employers from using credit reports for employment decisions except when a credit report is otherwise required to be obtained for a background check required by federal, state, or local law or regulation or for a national security clearance. H.R. 3621, the Student Borrower Credit Improvement Act, sponsored by Representative Presley, is also included in the legislation. This part of the bill would help student borrowers who may have been delinquent on paying their private student loans to repair their credit after they demonstrate a history of timely loan repayments for these loans based on what is affordable in their circumstances. Similar to how the credit reports of borrowers with federal student loans can be rehabilitated. Another key measure is H.R. 3629, the Clarity in Credit Score Formation Act, sponsored by Representative Stephen Lynch. This legislation would direct the CFPB to provide oversight and set standards for validating the accuracy and predictive value of credit scoring models, and it would promote innovation by requiring a study on how the use of non-traditional data might impact the availability and affordability of credit for consumers with limited or no traditional credit histories. Finally, the package includes H.R. 3618, the Free Credit Scores for Consumer Act, sponsored by Representative Joyce Beatty, which would direct the nationwide CRAs to add free copies of consumer credit scores to consumers' free annual consumer reports as determined by the CFPB. Additionally, certain categories of consumers can obtain free credit scores and reports more frequently, such as consumers who are a victim of identity theft, fraud, or a related crime. I note that I have filed a manager's amendment that adds a definition on medically necessary procedures, adjusts when certain financial rules need to be issued, and makes other technical changes. It also excludes from credit reports any adverse information about a federal employee and others who are affected by a government shutdown. I would ask that the committee make my amendment in order. Mr. Chairman, it's time to fix our outdated and broken credit reporting system. The issues addressed in this bill are long overdue reforms and important for the economic well-being of millions for its consideration, and I would be happy to answer any questions you may have.
Thank you very much, Mr. McHenry.
Thank you. Thank you, Chairman McGovern and Ranking Member Cole, and thank you for the opportunity to testify before the Rules Committee. Committee Republicans view this as another overt attempt by Democrats to codify their political agenda and that of their stakeholders. For more than a year, I've made the statement that committee Republicans stand ready to work with Democrats on this issue and issues that we generally agree are important to consumers. And today is no different. Committee Republicans stand ready to work with Democrats to help consumers. But today's hearing feels a lot like Groundhog's Day. In fact, during the Committee on Financial Services markup of the bills included in this bill, in July of last year, I made a number of points that are still relevant on this day. We've held one hearing on this topic back last February. I use the word topic loosely because the hearing had the CEOs of the three largest credit reporting agencies, not on reforms to the Fair Credit Reporting Act, which is what the bill does today. In fact, these bills weren't contemplated at the time of that hearing. So not once during the hearing did we discuss the bill we're discussing today, nor any of the components of the bill. So let me explain why this is important. On other issues in the committee, we've held subcommittee and full committee hearings, and Chairwoman Waters has been quite diligent about that, and I think that has given committees, Republicans and Democrats, more insight into what we're doing, and I think that's positive. We invited subject matter experts to give us feedback on what works and what doesn't. While we don't always agree on what works, I think it's a healthy process. But with respect to credit reporting, an issue of equal importance to Republicans and Democrats, which has never before been a partisan issue before Congress, we've thrown bipartisanship out the window. It needn't be that way. In fact, during our one hearing, I made clear I share Chairwoman Waters' concerns with the credit reporting agencies, their lack of competition, and what I deem as an oligopoly. I have concerns that their operations could be more consumer-friendly. And there are aspects of the original discussion draft that I thought had merit and should be explored in greater detail. We could have had a bipartisan bill before us today that could get signed into law. For example, I agree we should disclose public record data sources. I agree we should exclude paid medically necessary medical debt from consumer credit reports. I agree we should prohibit certain adverse information resulting from financial abuse or predatory lending as determined by a court of law and from being included in consumer credit reports. In fact, the substitute amendment I filed with this committee includes the reforms I just described and more. Reforms such as prohibiting the use of Social Security numbers to verify consumers. This is a key source of identity theft. We could have fixed that in this bill. It fails to do that. Facilitating online credit freezes and removal of credit freezes for minors. My committee questions in last February showed the complicated nature of trying to freeze one of your children's credit reports. It could have been included in this reform, and it does not. Studying the use of non-traditional data and credit scores, as well as codifying the CFPB's credit reporting registry. We could have done those things. It fails to do that. Bipartisanship was within our grasp. All my colleagues had to do is reach out and grab it. We had an opportunity for compromise that could have helped consumers and at the same time get signed into law. Instead, we have a Democrat bill under the guise of consumer protection that will destroy the accuracy and completeness of consumer credit files, ultimately impacting both the cost and accessibility of credit for all Americans, and potentially undermining financial stability in the process. Among other things, the Democrat bill removes important predictive data from credit reports, weakening the underwriting necessary for lenders to determine creditworthiness, which threatens, again, the stability of the financial system. Limits of the ability of employers to obtain a full picture of potential employees during the hiring process by banning the use of credit history as a factor in employment decisions, with only a rare few specific exemptions, not including exemptions for banks or those that are actively engaged in the use of hard currency or generally in the movement of cash. Arbitrarily shortened time periods for most adverse but accurate information on consumers' credit reports. Grants, as well, it grants the Consumer Financial Protection Bureau even more control to regulate and control credit scoring models and their development. And as I said, committee Republicans want to help the consumers. We could have had a bipartisan bill, but this bill, which socializes credit scores, isn't the answer. The bill and the concepts here, as a part of the discussion draft, to the hearing in February were very generalized and much changed from the bill before us today. And so I thank the committee for the opportunity to testify, and I'm happy to answer any questions.
Thank you. Thank you very much. I don't have any questions. Anyone in the committee have questions of this panel? Mr. Cole.
Just quick, I have a couple of things I'd like
Sure.
to submit for the record, if I may. First, the statement of administration policy, which says the President's advisors would recommend veto were this to pass.
Without objection.
And second, Mr. Chairman, a statement by the United States Chamber of Commerce opposing all 6 bills in this package.
Without objection. There being no questions, I thank you for being here, and you are dismissed.
Thank you.
That was good. Good.
You were held by the clock.
Yeah.
The chairman's strong suit.
Yeah. This closes the hearing on H.R. 3621. At this time, the chair will entertain a motion from the distinguished gentleman from Maryland, Mr. Raskin.
Thank you, Mr. Chairman. I move the committee grant H.R. 3621, the Student Borrower Credit Improvement Act, a structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee, print 116-47, modified by the amendment printed in Part A of the Rules Committee report, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule makes in order only those further amendments printed in Part B of the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against amendments printed in Part B of the report. The rule provides one motion to recommit with or without instructions. The rule provides for the consideration of the Senate amendment to H.R. 550. The rule makes an order or motion offered by the chair of the Committee on Foreign Affairs or his designee that the House concur in the Senate amendment with 2 House amendments. Amendment number 1, consisting of the text of Rules Committee, print 116-48, the No War Against Iran Act, and Amendment number 2, consisting of the text of Rules Committee, print 116-49, to repeal the authorization for use of military force against Iraq resolution of 2002. The rule provides 1 hour of debate on each House amendment, equally divided and controlled by the chair and ranking minority member of the Committee on Foreign Affairs. The rule waives all points of order against consideration of the motion and provides that the Senate amendment and the motion shall be considered as read. The rule provides that the question shall be divided between the 2 House amendments, that no further division of the questions in order, and that the divided question shall be considered in the order specified by the chair. Finally, the rule provides that if only one amendment is adopted, that amendment shall be engrossed as an amendment in the nature of a substitute to the Senate amendment to H.R. 550.
Thank you very much. You heard the motion from the gentleman from Maryland. Any amendments? Mr. Cole.
I'm going to dispense with a lot of debate, but I would like to suggest an amendment for H.R. 550, an open rule. I think we could reach some accommodation here. And then just a quick suggestion, every time we're crunched for time, can Mr. Raskins be the guy that reads the rule? I mean, that was great.
In the spirit of bipartisanship, yes. You heard the gentleman's amendment. Any discussion? Hearing none, the voters on the Cole amendment. All those in favor say aye.
Aye.
Opposed, no. No. You chair the noes have it. Clerk, call the roll.
Mr. Hastings. Mrs. Torres.
No.
Mrs. Torres, no. Mr. Perlmutter. Mr. Perlmutter, no. Mr. Raskin. Mr. Raskin, no. Miss Scanlon. Miss Scanlon, no. Mr. Morelli. Mr. Morelli, no. Miss Shalala. Miss Shalala, no. Mr. DeSaulnier. Mr. DeSaulnier, no. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Woodall. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mrs. Lesko. Mrs. Lesko, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 8 nays.
Members not agreed to. Further amendments, Mr. Cole.
Thank you very much, Mr. Chairman. Again, H.R. 550, my amendment would simply expand the list of exceptions for the use of force to include defense against an imminent attack against the United States or against a catastrophic attack against the state of Israel.
Thank you. Heard the gentleman's amendment. Any discussion? Any? Hearing none, the vote is on the Cole amendment. All those in favor say aye. Aye. Opposed, no. No. Neither chair, the noes have it. Clerk will call the roll.
Mr. Hastings. Mrs. Torres. Mrs. Torres, no. Mr. Perlmutter. Mr. Perlmutter, no. Mr. Raskin. Mr. Raskin, no. Miss Scanlon. Miss Scanlon, no. Mr. Morelli. Mr. Morelli, no. Miss Shalala. Miss Shalala, no. Mr. DeSaulnier. Mr. DeSaulnier, no. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Woodall.
Aye.
Mr. Woodall, aye. Mr. Burgess. Aye. Mr. Burgess, aye. Mrs. Lesko. Mrs. Lesko? Aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 8
Members
nays.
not agreed to. Further amendments. Mr. Woodall.
Thank you, Mr. Chairman. I have an amendment to the rule that the committee provide one motion to recommit with and without instructions to the Senate Amendment H.R. 550. I understand the House rules don't anticipate a motion to recommit. I understand Mr. Khanna's comment that isn't that clever of the majority leader to figure out a way to deny the Republicans a motion to recommit. But this is a topic that we all agree is serious. It has come without hearing. It has come without markup. And I would ask that the committee make in order that motion to recommit.
Heard the gentleman's amendment. Any discussion? Hearing none, the vote is
Mr.
up.
Chairman,
Yes.
I would just speak in favor of Mr. Woodall's amendment.
Okay.
I think that he's absolutely correct. This is an unusual situation, the way this is being brought, and the motion to recommit would seem to be the logical choice.
I don't want to prolong this debate, but I would urge the gentleman to refer to my opening comments. This is not an unusual process. My friends did this on the other side 15 times during the last session they were in charge. So I would urge a no vote. All those in favor say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it.
Roll call.
Clerk will call the roll.
Mr. Hastings? Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter? No. Mr. Perlmutter, no. Mr. Raskin?
Mr. Raskin?
Mr. Raskin?
No.
Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall?
Aye.
Mr. Woodall, aye. Mr. Burgess?
Aye.
Mr. Burgess, aye. Mrs. Lesko? Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 8 nays.
Members not agreed to. Further amendments.
Mr. Chairman?
Mr. Woodall.
Mr. Chairman, I have an amendment to the rule to make an order to provide the necessary waivers for amendment number 7 to H.R. 3621 offered by Ranking Member McHenry. You heard him talk about all the bipartisan things that were included in his substitute. I understand that his pay for is not germane, and recognizing that it would require that waiver. Again, this is a topic that has historically been bipartisan. I would ask that we make an order this amendment that would be bipartisan and have it
Thank
provide the
you.
waiver.
Well, the gentleman is germane, and the gentleman should know we tried to work with Mr. McHenry all afternoon on this, so I would urge a no vote. The vote is on the Woodall amendment. All those in favor say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it. Is there any other amendment or discussion? Hearing none, the question is now on the motion offered by the gentleman from Maryland, Mr. Raskin. All those in favor will say aye. Aye. Opposed, no. In opinion of the chair, the ayes resoundingly have it, and the motion is agreed to. The clerk will call the roll.
Mr. Hastings? Mrs. Torres? Mrs. Torres, aye. Mr. Perlmutter? Mr. Perlmutter, aye. Mr. Raskin? Mr. Raskin, aye. Ms. Scanlon? Ms. Scanlon, aye. Mr. Morelli? Mr. Morelli, aye. Ms. Shalala? Ms. Shalala, aye. Mr. DeSaulnier? Mr. DeSaulnier, aye. Mr. Cole? Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mrs. Lesko? Mrs. Lesko, no. Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk, report the total.
8 yeas, 4 nays.
Amendment, the motion is agreed to. Mr. Raskin will handle it for the Democrats. With no other business here, without objection, the committee is adjourned. Thank you for your patience, everybody.
Well, that was predictable at the end. All right, thank you guys for joining and for watching. I know I hate to pull you away from the impeachment trials to have showed you guys that stuff, but nobody else is talking about the fact that they had a hearing on limiting, President Trump's use of military force in Iran and Iraq and repealing the 2002 dealy bob. Nobody was talking about that, so I thought, I guess I'll just go ahead and do that. So thanks for watching, guys. Make sure that you're subscribed by hitting that big red subscribe button and turn on bell notifications by hitting the bell icon next to it. That way you can be notified when we go live, especially when we're doing things a little bit out of the ordinary like we just did. And you can check us out on GrowtheInfo.com, and you can find lots of good press releases and stuff on there too. And follow us on Twitter at GrowtheInfo and on Instagram as well. And I guess that's all.
Think about firstly in terms of seasons, it's the Lunar New Year holiday, and so usually this is a seasonal boost to the economy.
Shh. Copyright thing? No. Go away with your face. That's here, we'll do. There. Okay. Sorry. I'm like, no. Copyright. No. All right, guys. Thanks for watching. I guess I'm going to check and see if the impeachment trials are still going on. I think that they are. So I will restart streaming that. So I guess I will get to that and just leave it going. Actually, you know what? They probably don't have that much more time left tonight. Maybe I'll just leave it be. I got some other stuff going on anyway. So you know what? Y'all have a good night. I think it's just me in here. I don't think I actually have anybody watching right now because everybody's watching the impeachment stuff. So I'm just going to chill for the rest of the evening. And I hope that you all are doing the same and having, you know, as good of a time as you can with the whole Wuhan virus thing going on. Make sure that you keep an eye out for a video that we are going to be making on that. It's going to have a little bit of a different perspective than some of the other people I've seen reporting on it, you know. So I like to give a little bit of a different perspective here. So thank you guys so much for joining, and I hope you have a wonderful evening.